Okay. Well, this will try to have webinars throughout the year if there are important employment developments that arise. So we appreciate you coming to or attending today. We've got a lot of things to cover. If you do want to post any questions while we're going through this, we'll stop to answer questions at a few points during the presentation this morning. I want to start, of course, with the obligatory attorney disclaimer. This is what we do. We're attorneys. So I want to make sure that everybody is aware that this webinar should not be considered as providing any legal advice or legal opinions, because anytime you have a question or an issue that arises in employment, it's always dependent on the facts. So rather than rely on what we're going to cover today, you should always check with your counsel or with us to make sure that your particular situation is addressed with the proper legal advice. Okay, so let's get started by talking about our new California laws. So as some of you may be aware, 2018 was the year of Me Too, and that's where the legislature really focused its efforts in terms of new California laws. And there was a lot of high-profile incidents of sexual harassment involving entertainers, politicians, etc., all connected to the workplace. And there was a lot of examples where confidentiality provisions in harassment settlement agreements prevented exposure of harassment. The legislature was really concerned about that because they want to, bring these things to the light of day so that they can be addressed and hopefully erased from the workplace. So the legislature thought it was necessary to take some steps to protect people in the workplace from harassment and to strengthen those protections. So first thing the legislature did is it limited the ability of employers to require the release of harassment claims, which we'll talk about in some detail. Secondly, the legislature decided to limit confidentiality provisions in agreements settling harassment claims so that people would be free to disclose the facts regarding what happened to them and hopefully, again, help prevent harassment from occurring. Third, the legislature attempted to influence the courts, give some guidance to the courts on questions regarding liability for harassment. And really what the legislature wanted to do was tell the courts that we think that people should have more freedom to bring and prevail on sexual harassment claims. And I'll talk about what they did to try to influence the courts in this area. And lastly, and probably the thing that most of you have heard about, they've expanded the requirements for harassment training in the workplace. So we'll talk a little bit further along in the webinar today about the new requirements for training and what your company is going to have to do going forward in 2019. But first, I want to talk about a couple of these pieces of legislation regarding harassment, starting with SB 1300, which is probably the broadest piece of legislation that was passed by the legislature. And SB 1300 has a number of different components. The first component is that it prohibits certain agreements to release or waive Feha claims. And when I say Feha, that's referring to the Fair Employment and Housing Act. That's the California law that protects employees from discrimination, harassment, and retaliation in the workplace. So the legislature said you cannot require an employee to release claims or rights under Feha as a condition of employment. In other words, you can't tell an applicant or an employee that they have to sign some broad release of their ability to file a claim against the employer under Feha. So condition of employment means in exchange for a raise or a bonus or as a requirement to become employed or retain employment. So if, for instance, you say to an employee, look, I'm going to promote you to this new position, but as a condition of you getting this promotion, you're going to have to sign an agreement waiving any rights to bring a claim against us under Feha, that is now prohibited. Furthermore, SB 1300 says you cannot require an employee or an applicant to agree that they won't disclose any unlawful acts which occur in the workplace. In other words, you can't have a broad non-disparagement clause that says you won't say anything bad against the company, because employees, according to the legislature, need to be free to disclose certain things that happen to them in the workplace, particularly involving sexual harassment. Furthermore, you cannot require an employee applicant to agree that they do not have a Feha claim or that they haven't suffered from discrimination or harassment. So basically what the legislature wanted to do is make it very broad, a broad prohibition on employers forcing employees to waive any claims that they may have for harassment or discrimination. Now, what kind of agreements does this apply to? So this would apply to an agreement not just to waive sexual harassment claims, but to waive any type of claim under Feha. And Feha, of course, protects people from discrimination and harassment for race, for age, for disability, for religion, etc. So if you require people to waive any claims for harassment or discrimination, even if it's nothing to do with sexual harassment, that can be a problem under SB 1300. So this prohibition on releases or waivers does not apply to settlement agreements that are negotiated when an employee brings a claim. And here's what the legislature set out as the requirements for determining if it is a negotiated settlement agreement. If it is an agreement that is in settlement of a claim filed in a lawsuit in court, for instance, or a claim filed with an administrative agency such as the Department of Fair Employment and Housing, or as part of an ADR process, alternative dispute resolution. In other words, you arbitrate a claim of harassment or discrimination, but before the arbitration, you reach a settlement, you can have a release or waiver of Feha claims in that document. Or if an employee brings forward a complaint in an internal complaint procedure, they complain to Human Resources that they're being harassed, Human Resources does an investigation, they determine that in fact there was harassment, and they want to enter into some settlement with the employee, you can have as part of that settlement a waiver or release of Feha claims. So generally speaking, when we're talking about settlement agreements of claims brought by employees, you can have a release. What you cannot do is force employees to release those claims in advance as part of some deal that you strike with the employee to give them a bonus. Hey, if you agree to take this bonus, you're going to waive any claims. That would not work. But when the employee brings forward a complaint, whether that's in court or internally, and you want to settle it, you can require a release of claims. Now, under this law, there's a definition of what negotiated means. And what the legislature said is negotiated means the employee voluntarily, deliberately, and knowingly agreed to the settlement, and the employee had an opportunity to retain an attorney. Now, the employee doesn't have to have an attorney. They're not required to retain an attorney in order to sign one of these settlement agreements with a waiver. But what you need to make sure that you do, and this is the key practice point here, is make sure that your settlement agreements, whatever type of settlement agreement you enter into, has language that qualifies that settlement agreement as a negotiated settlement agreement. In other words, it says the employee is voluntarily agreeing to it, the employee had an opportunity to get an attorney, et cetera, et cetera. Now, here's the interesting thing about SB 1300. It's an open issue whether this particular piece of legislation prohibits a release of Feha claims in a severance agreement. In other words, very often employers, and rightfully so, want to give employees some sort of severance in return for an agreement that the employee releases all claims arising from their employment, including claims under Feha. So a separation agreement where there's severance is not a settlement of litigation. So under the text of the law, it doesn't necessarily fall within the definition of a settled negotiated agreement. But on the flip side, when you get a separation agreement based on severance, you're not requiring somebody as a condition of employment to sign that agreement because they're no longer going to be employed. So you can argue that separation agreements are not allowed to have a waiver of Feha claims under 1300, but I can also argue that separation agreements aren't a condition of employment and therefore they don't fall under SB 1300. Who knows how this is going to come out? Somebody could argue that severance pay is considered a bonus. I would argue that it's not. The point of all of this is that we don't know yet. It's gonna have to be something that is litigated. So my advice is that until there's some clarity on this, it's best, if you're going to have a separation agreement with someone where you're paying them severance, to include Feha release language, understanding there is a possibility that someone can challenge enforcement. I think that's probably not going to be something that happens very often. And the reason is that plaintiffs' employment attorneys all work on a contingency. And if someone's going to challenge this all the way up probably to the California Supreme Court, they're going to have to put a lot of time and effort into that. And that's probably not a good use of their time. So it's unlikely that this is going to get challenged in most cases, and it may not get challenged all the way to the Supreme Court for some years. And if you stop using a Feha waiver, now you're not getting the full value of what you're paying for with that severance. And that full value is knowing that you're not going to get sued. So I think you should include Feha waivers in severance agreements. Yes, there's a possibility the agreement's going to be challenged, but probably that's a pretty remote possibility. Okay, what else did SB 1300 do? One of the things that SB 1300 said is that employers can be liable for any type of harassment by non-employees. Prior to SB 1300, you could only be liable as an employer for sexual harassment by non-employees. So for instance, the classic example, the UPS driver comes into the office and he makes sexual comments about some of the people working there, and they complain. And if the employer should have known or knew about that harassment and failed to take corrective action, the employer could be liable for sexual harassment by a non-employee. But prior to SB 1300, you could not be liable for, let's say, racial harassment or age harassment or disability harassment by a non-employee. But SB 1300 changed that. So what do you do if you find out that a non-employee is engaging in harassment of your employees? Well, you need to take active steps to deal with that particular situation. If it's a UPS driver, you need to call UPS and tell them, get another driver. If it's a customer, you have to weigh what is the situation here and whether or not the appropriate action will be just to tell the customer to knock it off or to tell the customer to never come back. That's always going to depend on this particular circumstances. So in those situations, you really need to talk to counsel and find out what is the appropriate action to take, because if you don't take appropriate action or you don't document what you did, you're opening yourself up to liability. So SB 1300 also contained a limitation on employers' recovery of fees and costs for frivolous harassment or discrimination cases. So under SB 1300, if someone brings a claim and it's just completely bogus, you can't go after that employee to recover the fees and costs you spent to defend the company unless you can establish that the case was frivolous, unsubstantiated, or groundless when filed, or the employee continued litigating after knowing the case was frivolous. it's a higher standard to meet. And the important thing that SB 1300 did with this regard is it says that even if you make an offer of compromise under Code of Civil Procedure 998. Now, I know this is a little inside baseball, lawyer stuff, right? But there's an ability in cases to make an offer to settle a case, and if you make it a 998 offer and the employee turns it down and the case goes to trial and the employee doesn't recover more than what you offered in settlement, then you can go back after that employee for costs and fees. But under SB 1300, unless you can prove, even in the case where they didn't beat the 998 offer, unless you can prove that it was groundless or unsubstantiated when it was filed or when the employee should have known that the case was frivolous, you're not going to get your fees and costs back. So the practical effect is it's going to be very hard for employers to pursue malicious prosecution or frivolous prosecution in harassment or discrimination cases. Next, SB 1300 also had this section that talks about legislative intent. I mentioned it at the outset that the legislature wanted to send a message to the courts that we believe this is how you should interpret the law. Now, there's some commentators out there that say that this is binding on the courts. I don't think that is the case. I think this is just the legislature saying, hey, courts, we think you should do this. But of course, you know, the courts are a separate branch of government. So it's an open question whether or not they will follow the suggestions of the legislature. But here's what the legislature said regarding harassment cases. Number one, hostile work environment claims should rarely be dismissed on summary judgment. One of the defenses that we have as employment attorneys defending employers is to say that, look, in a hostile work environment case, which is the most typical type of sexual harassment case, what the employee is complaining about didn't rise to the level of hostile work environment, and therefore the case should be dismissed before we even get to trial. And very often the courts agree. And you're able to defend, even if there was something that maybe could be considered sexual harassment, it just isn't enough to rise to the level of hostile work environment. It's not severe or pervasive. And the legislature is telling the courts, hey, we don't want you to dismiss those cases. They should go to trial. Secondly, the legislature said the employee shouldn't have to prove that the effect of a hostile work environment was a decline in the employee's productivity. That's one of the factors of a hostile work environment. And there are some cases where the courts have said, look, if the employee is not able to prove that, they don't have a hostile work environment claim. The legislature is saying, we don't think courts, that those decisions were correct, and we don't think the employee has a burden to show that there was any effect on their productivity by the harassment. Furthermore, the legislature is telling the courts that we believe a single incident of harassment is sufficient to prove that there is a hostile work environment. And therefore, even if the employee is only claiming there's one incident of harassment, that case should go to a jury. The standard for proving hostile work environment is you have to show that the conduct was either severe or pervasive. Pervasive meaning that it was occurring more than once. And the legislature is basically telling the courts, we think that a single incident, whether or not that single incident was pervasive or severe, shouldn't be determined by you, it should be determined by a jury. We'll see how that one goes, because I think the courts are going to be reluctant to adopt that. And lastly, the legislature told the courts that they believe stray remarks by a non-decision maker should be taken into account in determining a decision maker's discriminatory intent. Oh my gosh, that sounds like a lot of legalese. Let me explain what that means. Let's say that I am making a decision to terminate an employee, and I haven't made any comments about that employee's age. There's no evidence that age was a factor in my decision. But the employee says, hey, you know, one of my coworkers, Fred, kept making comments about how old I was and that I can't use a computer because I'm too old to understand that stuff. And even though Fred didn't have any say in the decision to terminate me, I think Fred's stray remarks are evidence of discriminatory intent by Erick. And there's a lot of decisions where the courts have said, no, that really doesn't, it's not evidence of what Erick's state in mind was, his motivation for terminating the employee. What the legislature has told the courts is, we think that stray remarks should be considered evidence of Erick's motivation for laying off an employee when it comes to discrimination. So the courts aren't bound to follow this, but it could have impact on judges. And the whole upshot of all of this is it's going to make it harder to defend harassment and discrimination cases. So bottom line is, severance agreements where people release these types of claims are cheap insurance. And as I said earlier, I think you can still enter into those separation agreements where people waive their rights to file harassment or discrimination claims. And my advice would be, in most circumstances, it's a good idea to offer some severance so that you avoid running into these difficulties with defending harassment claims. So let's take a look at whether or not we have any questions before we move on. So, let's see, questions. No questions. Anything in chat? Okay, all right, always want to check. Let's move on. So let's talk about next a couple of other pieces of legislation that were passed regarding harassment before we talk about harassment training. So SB 820, Senate Bill 820, different piece of legislation, basically said settlement agreements cannot prohibit disclosure of factual information related to harassment, discrimination, assault, or retaliation based on sex. In other words, in a settlement agreement, you can't have a gag order on the employee. There has to be a carve-out that allows that employee to disclose what happened to them. So even if you can make the agreement confidential, you cannot make the employee be prohibited from sharing the facts about what happened to them. Now, this only applies to settlement agreements involving sex or gender. It does not apply to a settlement agreement regarding race or age or disability. You can still have a broad confidentiality provision in those types of agreements. But if you're settling a sexual harassment or discrimination or sexual harassment case, you cannot prohibit the employee from talking about what happened to them. Now, there is a carve-out in this law. It only applies to agreements entered into after commencement of litigation, okay? So in other words, if the employee files a lawsuit or files a claim with the DFEH, and you're going to settle that case, then you cannot prohibit disclosure of factual information. But if you have an agreement outside of litigation, whether that's a separation agreement, after a demand letter, an internal complaint, whatever the case may be, if the employee hasn't filed an actual lawsuit or a charge, then you can have a broad confidentiality provision. And furthermore, under SB 820, you can always, no matter what kind of settlement agreement it is, prohibit disclosure of the amount paid in settlement. So if you're settling the case for $1 million, you can prohibit the employee from disclosing, hey, I got $1 million. What you can't prohibit is the employee describing what happened to them. Also, SB 820 says employees can request confidentiality of identity or any facts that would reveal their identity. And furthermore, you just need to make sure that whatever you're settling is carefully drafted. That's why you need to have counsel. Don't try to do it on your own. You need to make sure that you're not putting something into that settlement agreement that can end up getting that settlement agreement overturned. Okay. Another piece of legislation having to do with sexual harassment, AB 3109, Assembly Bill 3109, says that you cannot have language in a settlement agreement that prohibits the employee from testifying pursuant to a court order or subpoena with regards to the following things: sexual harassment or criminal conduct in the workplace. So you can't put it, again, you can't force the employee not to talk about facts, and you also can't force the employee not to testify if what they're being called to testify about is sexual harassment or criminal conduct. Now, criminal conduct is really broad. That's a broad term. So a lot of things in the labor code actually end up being criminal conduct. For instance, failing to pay overtime, failing to pay minimum wage, misclassifying people. Those are all misdemeanors. So you have to be very careful in not preventing people from testifying in the future about those types of abuses in the workplace. So again, the message here is you got to be really careful with settlement agreements. You can't just send the employee a letter saying, hey, employee, I'm going to pay you $50,000, and in return you agree not to sue me and not to disclose what happened in the workplace. That's going to be a problem. Okay, let's talk about sexual harassment training, which is probably the one piece of legislation that's received the most attention. As probably most of you are aware, a number of years back, the legislature passed Assembly Bill 1825, which required supervisor harassment training for employers that have more than 50 employees. And what the legislature decided this year was, look, this doesn't go far enough. We need to extend this down to employers with 5 or more employees. So, effective January 1st of this year, if you've got 5 or more employees in California, you're required to provide sexual harassment training to your supervisors and managers. And that 5 employees would include temporary employees, okay? It does not change, however, the content of the training, okay? The content, you still have to provide training on gender identity and gender expression, sexual orientation, training on sexual harassment and prevention of sexual harassment, training on bullying and abusive conduct. So the content, the 2-hour requirement, the requirement that you do it every 2 years, or 6 months after hire or promotion into a supervisor position, none of that's changed. The only thing that's really changed is that if you previously were not covered under 1825 because you had 50 or more employees, and now you're covered, you have to provide the training by January 1st, 2020, which raises the question, what if I was not a covered employer under 1825 because I had less than 50 employees, but I just decided nevertheless to provide the training to my supervisors and managers last year? Do I have to do it again this year? The answer is yes, because you weren't covered. And the law says newly covered employees must complete the training this year. So if you do it this year for your supervisors and managers, then you got it done for 2 years, you're good. What if you were an employer that was covered under 1825 and you had 50 more employees and you provided your supervisors and managers training last year? Do you have to do it again this year? No. You just would have to provide it to them every 2 years because you were covered. So it only applies, you only have to provide the training this year if you are a newly covered employer. Okay, the second thing that SB 1314 did is it extended the requirement to provide sexual harassment training to all employees. Prior to this year, there was no requirement to train employees on sexual harassment, but the legislature decided this is such an important issue, we want to require all employers with 5 or more employees to provide this training to all their employees. So the requirement is that you provide 1 hour of training on sexual harassment to be completed by January 1st, 2020 by a qualified trainer. If you trained employees previously, that does not count. You have to provide the training this year in order to be compliant with SB 1314. And who is a qualified trainer? It's basically, you don't have to necessarily hire somebody from the outside or go to one of the web-based providers. you can have an internal person, but they have to have some sort of qualification, whether that's, you know, a human resources degree, a SHRM certification, something that you can say, hey, they know what they're talking about. In other words, you just don't want to task your payroll manager who was recently promoted from an accounts payable position, who has no human resources background or training, to be doing this training. That wouldn't make sense. This can be completed individually or in a group setting. I will say that there's a lot of web-based providers that are out there, and CalChamber would be the one that is, you know, I think one of the better providers. It's pretty reasonable, and you can sign up and have the employees complete a web-based training, and that'll meet your requirements. They track it, they, you know, issue a certification. That's probably the easiest way to satisfy this. So once you train your employees this year, you won't have to train them again for another 2 years, unless, of course, you hire people and then you've got to train them within 6 months of hire. Now, there are some special rules for temporary and seasonal employees. Temporary and seasonal employees are covered by this. So you do have to provide that training. However, that requirement to train does not kick in until next year. So for temporary and seasonal employees, effective January 1st, 2020, you have to provide training if they work 30 days. Okay, so once they pass 30 days, then they got to provide training to them, or they work 100 hours, whichever one you hit first. But if they're being brought in through a temp agency, okay, the temporary agency is supposed to train their own employees. The employer is not on the hook for that. Now, that brings me to the issue of having a written contractual agreement with your temporary agency. It's really important to have that, because there's a lot of things that you need to do to protect yourself. One of those things would be, in a contract with your temporary agency, a recognition by the temporary agency that it's their responsibility to provide that training to their temporary employees, and that they will meet that responsibility and they will indemnify you if they fail to meet that responsibility. So it's really important to look at, if you don't have a contract, you need to have one in place. And if you do have a contract, ask your temporary agency that we're going to rewrite this contract to make sure that you know that you're supposed to provide the training to the temporary employees that you're providing us. If your training is completed within this 1 year period from January 1st, 19 to January 1st, 20, you don't need to do it again for employees for another 2 years. Now, there's one other thing I want to mention about the employee training. There is, as part of the legislation, a requirement for the DFEH, the Department of Fair Employment and Housing, to create an online training video for employees. That is going to be free. Just like, Larry says for the mattress company, your training will be free. But it's supposed to not be up until late 2019. So when we're talking about a state agency, I'm not sure I'd rely on the state to get it up in time to have it done by the end of the year. I would probably rely for now on the paid training, but hopefully they'll have it up by the end of the year, and then you'll be able to utilize that on a go-forward basis with the new employees that you hire. There is, however, up right now a sample presentation and toolkit that you can use to provide employee training. And it is, I included the link right there. We will send you the slides if you request it by sending us an email. My email will be at the end of the presentation, and in those slides you'll have that link if you want to look it up, or of course you can just use Google and you should be able to find it. But it is up there for your use right now, just they haven't finished the training video yet. Okay, any questions about sexual harassment training requirements? Let's take a look. Does WBT qualify? WBT. I'm not sure what that means, Melissa. If you can clarify. WBT. Wow, that may be one you send me afterwards. Oh, web-based training. Wow. See, that shows how technologically adept I am. Yes, web-based training qualifies not only for the supervisor manager training, but also for the employee training. So you can, and that's probably the easiest solution rather than bringing in a trainer to conduct training, is just go to one of those web-based training companies. The DFEH training, when they post it, will be web-based, and like I said, that'll be free. So that'll be a great resource for people to use when it finally goes up. Okay, so let's talk about some other new laws. I want to mention a couple real quick. Number one, lactation accommodation. As probably most of you are aware, you're required to provide an accommodation to employees who need to express breast milk at the workplace. And there was an ambiguity in the law on whether or not you had to provide a location that was separate and apart, or whether you could put something in the restroom that allowed employees to express milk in the restroom. And the clarification is that the legislature said, no, you can't do it in the restroom. So you don't want to have a requirement that people have to go into the bathroom to do their lactation. You need to set aside a separate area. Number two, there was a clarification on salary history prohibitions. You're probably remembering there's been a number of changes to the equal pay laws over the last couple of years, and there was some prohibitions on asking people about their salary history, applicants in particular. And there was some ambiguities over, well, can you ask them about their desired salary, et cetera. So the legislature clarified that, and you can ask an applicant about their salary expectations. You cannot ask an applicant about their salary history. And also, part of the equal pay laws said that applicants or employees are entitled to look at a pay scale. So if somebody says, hey, I want to see the pay scale for the position, you're supposed to turn over a copy of that pay scale. There was a clarification that you don't have to give anybody who just sends in a resume on Monster or Indeed a copy of your pay scale. Applicants are only entitled to that after completing an initial interview. If they ask for it, then you have to give it to them. Pretty minor stuff, but still I want to mention it. Another thing I wanted to mention is, as part of this whole sexual harassment thing, one of the things, of course, for employers is, well, what happens if I fire somebody for engaging in sexual harassment, and then another prospective employer comes along and says, hey, what about Eric? He's applying for work here. Can I say anything? And my answer prior to 2019 would be, yeah, you probably shouldn't, because you don't want to run into a claim that you're engaging in defamation, where the employee says, hey, they fired me for sexual harassment, I didn't do it, and they knew I didn't do it, and they told people that I did it, and therefore they defamed me. So this new law says that an employer is protected and an employee is protected if a credible report of harassment is made, or the employer does an investigation and says, hey, we think this was harassment, and they fire the employee for that purpose. They can tell a prospective employer that the individual is not eligible for rehire due to workplace harassment, and they cannot be sued for defamation. Again, the purpose of this is to, take the cloak off of sexual harassment and make it easier for employees to spread the news of what happened to them. Now, of course, there's a flip side of that. What if I was accused of harassment and I didn't do it? That's a difficult situation. And employers now could tell a prospective employer, you're not eligible for rehire because you engaged in workplace harassment. And there's not a recourse you have against that former employer. This is, I think, good for employers. I still probably would tell my clients that if you get a request for a reference check or whatever, your best bet is to just name, rank, serial number, right? Yes, he was employed here, he was employed in this position, and these were his dates of employment, and that's about it. Even though this law went into effect protecting you from defamation, I still would be very nervous about sharing information about why you terminated somebody. Okay, moving on. There's a couple of court decisions that I want to talk about that are very important. One of them is something that probably all of you have heard about, hopefully, and we even did a webinar on this, but I did want to mention this again. This is Dynamex, because there has been some developments in this area. So Dynamex is a case involving independent contractor status, and it's a California Supreme Court case. And as you probably heard, the California Supreme Court said, we are going to adopt a new test for independent contractor status called the ABC test. If an entity wants to prove someone is an independent contractor, they must prove each of the following factors. A, that the worker is free from the control of the hiring entity, both by contract and in fact. Meaning it's not enough just to say in the contract, the independent contractor agreement, hey, this person doesn't have to follow our directives. They can determine the manner and method and means of providing the services or doing the job that they've been retained to do. That also has to be true in fact, meaning you actually have to not exert control. That's the easy one to meet. This is the hard one, the B. The worker performs work outside the usual course of the hiring entity's business. In other words, if your business is producing widgets and you hire an independent contractor and that independent contractor is doing a job related to producing widgets, it's in the course of your business, then they're not going to meet the ABC test. So to use a comparison, your widget producing company has a sink in the employee break room and the sink is stopped up and you're going to bring in a plumber to unclog the sink. Well, that's not something in the course of producing widgets. That's separate and apart. That looks like an independent contractor, right? Or if you're going to hire a company to do a web design for your marketing efforts, okay, that's not in the course of producing the widgets. That's separate and apart. That's probably an independent contractor. But if you're hiring somebody to do quality assurance on the widgets, well, that's in the course of the business. You want to make sure you're producing quality widgets. That quality assurance person is not going to meet the ABC standard because they're performing work within the usual course of your business. And then the C of the test is that the worker is customarily engaged in a trade, business, or occupation of the same nature as the work performed. In other words, they're out there in the marketplace selling themselves as a plumber, okay? And that's their trade, that's their occupation, that's their business. They're out there trying to get other customers to retain them, as opposed to a worker who is just working for one entity. That looks more like an employee, and under the ABC test, you wouldn't be able to prove independent contractor status. So, if you can't prove all of these three elements, in other words, if you fail on any of them, the worker's an employee. That's what Dynamex says. Now, that is compared to the totality of the circumstances test, which is the traditional test that has been used for independent contractor status. And the reference there to Borrello is the lead case, SG Borrello, which says that you're not just looking at these three factors. You're looking at a whole host of factors, and it's all a balancing test, and it's a lot more mushy, and it gives you a lot more leeway to argue independent contractor status. The Dynamex decision said, nope, it's these three, that's it, and if you can't meet any one of them, you're done. It's not a totality of the circumstances. Here's the important thing to understand about Dynamex. It only applies to claims of employee status under the wage orders. When I say the wage orders, that means the Industrial Welfare Commission wage orders that apply to non-exempt employees, hourly employees. The wage orders contain things like minimum wage and overtime and rest periods and meal periods, et cetera, et cetera. So if someone is bringing a claim under the wage orders, I didn't get overtime, I didn't get my meal periods, I didn't get my rest periods, and you try to assert a defense that they were an independent contractor, under Dynamex, you're going to lose. But if they're not covered under the wage orders, if they're an exempt employee, meaning they fall within one of the exemptions, they're an outside salesperson, they're a professional, they're a managerial, they're an administrative, and they meet all those requirements, then Dynamex doesn't apply because they don't have claims under the wage orders. They're not non-exempt employees. So Dynamex does not apply to claims under the Labor Code, claims of discrimination or harassment under Feha, or wrongful termination. And that was affirmed by a Court of Appeals case called Garcia versus Border Transportation Group, which came out late last year after Dynamex, which said, yeah, Dynamex is limited to the wage order claims. If someone is filing a wrongful termination claim, it still is a defense to argue that they are an independent contractor under the totality of the circumstances test of Borrello. So Dynamex is a little more limited. It also does not apply to situations where it's trying to be determined whether somebody is an employee or independent contractor for unemployment benefits or taxation. So if you get an EDD audit, the EDD is going to be applying the Borrello test, totality of the circumstances, not the Dynamex test. So what's the upshot of all of that, okay? You have to be very careful as an employer if you're bringing in independent contractors that would not meet the Dynamex test and who would be considered non-exempt employees. So if you got somebody who, if you hired them, they'd be hourly, then it's really hard to make them independent contractors. If, on the other hand, you've got somebody who would be exempt anyway, then making them an independent contractor is not going to get you into trouble under Dynamex, at least for the present, because if they bring a wage claim, you would have a defense that they were exempt anyway. So Dynamex is a little more limited. A lot of people made a very big deal about Dynamex. It still is a big deal, as I'll talk about a little bit later, but it's a little bit more limited. Now, second case I want to talk about, very important case, not because of the details of this case, but because of the concept of paying overtime on bonuses, okay? And this is a case called Alvarado versus Dart Container. It's a California Supreme Court case, came out last year. So let me just talk about the facts of the case. In this case, the employer, Dart Container, was paying employees a flat sum attendance bonus. So they were trying to get people to come in and work on weekends. So they said, in addition to your hourly rate, if you show up on a Saturday, we're going to give you 15 bucks. If you show up on a Sunday, we're going to give you 15 bucks. It never varied. It was 15 bucks. Flat sum attendance bonus. Now, in California, if you pay employees a bonus or commission, and it's a non-discretionary bonus, meaning it's tied to some metric, it's not just out of the goodness of your heart, okay? Then you need to pay overtime based on that bonus compensation, not just their regular rate, their regular hourly rate. In other words, you need to calculate that overtime by determining the regular rate of pay. In Dart Container, the company calculated overtime. So they did the right thing, they thought. They took the bonus, the $15, let's say the employee earned $30. They earned 2 bonuses in a pay period, and they divided that by all their hours worked. Well, they worked on Saturday and Sunday, so let's say they worked, 60 hours, and you divided the $30 by 60 hours. That comes out to a certain amount of extra overtime that's owed, and then you multiply that by 0.5, and that's what you determine how much is owed to the employee. So the company thought it was doing the right thing, but plaintiff's attorneys said, no, that's not the way to calculate it, took it all the way to the Supreme Court, and the Supreme Court said overtime on a flat sum bonus is not calculated by dividing all hours worked. Unlike the federal rule, in California, if you have a flat sum bonus, you have to divide by the straight time hours worked only, and you need to multiply that by 1.5, which means that the employee gets more overtime on a flat sum bonus. Okay? Now, that does not apply to situations where it's not a flat sum, where the bonus varies based on productivity or other criteria. Hey, your bonus is going to depend on, how many widgets you manufacture. That's going to vary week from week. Then you would divide by all hours worked. Okay, now I know you're all thinking to yourselves, I didn't sign up for a webinar to learn about math. Here's the important thing to take away from Alvarado, okay? If employees are receiving any type of non-discretionary bonus, a safety bonus, a bonus for referring new hires, anything that's tied to a particular metric, okay, as opposed to just a Christmas bonus, hey, I love everybody, it's the holidays, here's money. That's a discretionary bonus that does not have to be included in overtime, but if it's a non-discretionary bonus, you have to compute that, and you need to compute that based on the period of time that the bonus is earned. So let me use an example. Let's say you give a safety bonus, and if there's no accidents over a quarter, 3 months, then all the employees get $150, okay? If you're doing that over a quarter, then you need to go back and calculate how many overtime hours were worked during that quarter and figure out what is owed on that overtime, not just the pay period where the employee receives the bonus. You have to go back for that entire period. So, and of course, that's going to be a flat sum bonus, right? Because it's $150. So here's my message, okay? If your company has any type of commission or bonus structure for exempt or non-exempt employees, exempt employees don't matter, right? Because they're not entitled to overtime. But for non-exempt employees, you need to take a look at whether or not you're paying overtime on that. And if you're not, you need to call counsel and you need to figure out how to deal with it, because we're seeing more and more class action lawsuits for failure to pay overtime on bonuses. And so Alvarado is really just a reminder that you need to take a look at this. And if you are paying overtime on that bonus, make sure you're doing it correctly. Okay. Any questions arising from that? Clear as mud, right? Okay. Well, if anybody does have questions about Alvarado or calculating bonuses based on overtime, feel free to email me or call me afterwards, because it is a very, very complicated area of law. I just wanted to highlight that this decision came out and you need to be very careful on paying bonuses or commissions. Okay, moving on. We're almost finished. I want to talk real quickly about what to expect in 2019. Number one, I've been saying this for a couple of years. If you don't have a mandatory arbitration agreement for your employees, get it in place, because it's not going to be around for long. So a mandatory arbitration agreement is an agreement where the employee and the employer agree any type of employment claims will be subject to arbitration, and the employee waives any ability to bring a class action claim. That's the real value, okay? And that can be very effective in defeating a class action. However, the legislature for the last 2 years has passed bills that would ban mandatory employment arbitration. And Governor Brown vetoed them both times. And you probably know that Governor Brown's no longer around. He's on a ranch somewhere up in Northern California. I would lay really good odds that Governor Newsom is going to sign that legislation this year. It's coming back, and so, you know, if you don't have it, get it while you can. Might as well use it while you can, because it's going to be gone, I think, by the end of this year. Number two, there is a move afoot in the legislature to take the Dynamex ABC test and pass a law saying that it applies to all employment decisions, not just the wage orders. And it's already been introduced into the I think the Assembly. So keep an eye on that, because if the legislature passes that, Dynamex could have much broader implications than it does now. Next, I expect that we're going to see an expansion of paid leave benefits, not just the paid leave benefits that are provided by the state, but also forcing employers to pay the difference, so that if employees go out on paid leave, whether that's for baby bonding or for FMLA/CFRA, that the employees don't lose any wages. I think that's definitely on the horizon. Keep an eye out for that. And lastly, there is an effort in the legislature to give us some relief for businesses on PAGA. PAGA is Private Attorneys General's Act. It allows employees to sue their employer on behalf of all other employees for violations of the labor code. It's the employment lawyer dream, because plaintiffs' lawyers get to bring PAGA actions for almost anything and extort money from all of you. And there is a move afoot to limit some of the abuses under PAGA. So call your legislators, right? This is one that would really help businesses if we can put some limits on PAGA. So that's something to look for in 2019. Okay, so here's my contact information. My email address, ebecker@cwlawyers.com. If you want a copy of the slides, I'll be happy to email them to you. We'll also be posting this presentation up on our website. Again, if you have any questions regarding any of the things that we've covered today, I know that we went through quite a bit of material in a short period of time. Please feel free to reach out to me. I'll be glad to answer any questions that you have. We appreciate you attending today. Thank you very, very much. And please keep an eye out for further webinars coming up this year, so we can talk about more fun and exciting things in the world of employment law. Thanks a lot. Have a great day.